The Grand Chamber of the Supreme Court hummed with anticipation as Congresswoman Jasmine Crockett approached the podium. Her bold crimson suit stood out against the somber wood paneling and marble columns, a deliberate choice for what she knew would be a defining moment. At 43, the freshman representative from Texas carried herself with the quiet confidence of someone who had faced tough battles before, though none quite like this. Justice Clarence Thomas sat at the far end of the bench, his expression impassive as usual. The court's most senior justice, with over 3 decades of experience, had developed a reputation for his conservative jurisprudence and originalist approach to constitutional interpretation. In recent years, he had become more vocal during oral arguments after decades of famous silence, often asking pointed questions that revealed his skepticism toward expansive interpretations of civil rights protections. The case, Harris County Voters v. Texas Election Board, challenged new voting restrictions that plaintiffs claimed systematically disadvantage minority communities through reduced polling places, strict ID requirements, and limited early voting options. As both a sitting congresswoman and a former civil rights attorney with extensive trial experience, Crockett had been granted the rare opportunity to argue before the nation's highest court. The stakes couldn't be higher. With upcoming elections looming, the court's ruling would potentially impact voting access for millions of Americans and set precedent for similar laws being considered across the country. With a 6-3 conservative majority on the bench, voting rights advocates viewed the case with trepidation. As Chief Justice Roberts nodded for her to begin, Crockett had barely completed her opening statement when Justice Thomas leaned forward, activating his microphone. What followed would start as a tense exchange, but end with one of the most extraordinary moments in recent Supreme Court history. A single fact so devastating that it would leave Thomas in stunned silence and potentially alter the trajectory of voting rights jurisprudence for years to come. Before we dive into this incredible confrontation that has everyone talking, take a moment to like this video and subscribe to our channel for more coverage of the most important legal and political showdowns shaping America's future. The morning had begun with the usual formalities. The marshal had called the court to order, and the justices had entered in their black robes, taking their seats behind the elevated bench. The audience, consisting of legal scholars, journalists, civil rights leaders, and fortunate members of the public, watched attentively as Crockett approached the podium. "Mr. Chief Justice, and may it please the court," Crockett began confidently, "the right to vote is preservative of all other rights in our democracy. When that right is systematically burdened for some citizens more than others based on race, the Constitution and the Voting Rights Act demand judicial intervention." She had barely finished this introduction when Justice Thomas activated his microphone. "Congresswoman Crockett," he began, emphasizing her political title rather than addressing her as counsel, "your argument relies heavily on statistical disparities in the impact of these voting regulations. But this court has repeatedly held that disparate impact alone doesn't establish a constitutional violation. The 14th and 15th Amendments prohibit intentional discrimination, not merely policies with uneven outcomes. What direct evidence do you have of discriminatory purpose?" It was a standard opening from Thomas, consistent with his long-held narrow interpretation of constitutional anti-discrimination provisions. Several journalists in the press section began taking notes, anticipating a fairly typical exchange on the intent versus impact debate that had characterized voting rights jurisprudence for decades. Crockett nodded respectfully. "Justice Thomas, we have several forms of evidence suggesting discriminatory intent beyond statistical disparities alone. First, the timing of these regulations is telling. They were enacted immediately following an election with historic turnout among minority voters. Second, the legislative process deviated from normal procedures, with these provisions rushed through without typical committee review. Third, the specific restrictions target voting methods disproportionately used by minority communities." Thomas appeared unimpressed. Ms. Crockett, that's all circumstantial. Legislatures frequently act quickly after elections, and correlation doesn't prove causation regarding which voting methods different communities prefer. Do you have any direct statements from legislators expressing racial motivation? We have statements from several legislators expressing concern about certain communities having too much influence, Crockett replied. While they didn't explicitly mention race, the context makes clear, Thomas interrupted. So, no explicit racial statements. You're asking this court to infer racial motivation based on coded language and statistical patterns. Doesn't that approach essentially allow courts to invalidate any election regulation with disparate impacts, regardless of legitimate state interests in election security? His tone carried a distinct skepticism that suggested he viewed her position as not just wrong, but potentially dangerous to the constitutional order, a judicial overreach that would substitute courts' policy preferences for legitimate state authority. Crockett began responding, Justice Thomas, under Arlington Heights, this court established that discriminatory intent can be inferred from... Thomas interrupted again. I'm familiar with Arlington Heights. My question is more fundamental. Your theory seems to suggest that when a state implements neutral voting, procedures that apply to everyone, courts should nonetheless strike them down if they statistically affect some groups more than others. That approach would effectively federalize all election administration, wouldn't it? The question was framed as a trap. If Crockett agreed, she would appear to be advocating for unlimited federal control over state elections. If she disagreed, she would undermine her own case. Several observers noticed Justice Kagan and Justice Jackson exchange glances. Thomas's questioning had become increasingly pointed, clearly designed to expose what he viewed as fatal flaws in Crockett's constitutional theory. Crockett paused briefly, recognizing the critical moment. Justice Thomas, our position absolutely recognizes limiting principles. Statistical disparities alone don't establish a constitutional violation. However, when combined with historical context, suspicious timing, procedural irregularities, and targeting of specific voting methods known to be used predominantly by minority communities, the inference of discriminatory intent becomes compelling. Thomas leaned forward again. Historical context is certainly relevant, Ms. Crockett. But history also teaches us something important about voting rights jurisprudence. His tone shifted slightly, taking on what some observers would later describe as a lecturing quality. For decades, Section 2 of the Voting Rights Act was interpreted to prohibit only intentional discrimination. It wasn't until the 1982 amendments that Congress explicitly expanded it to include a results test. The Constitution itself, however, has never been amended to include such a test. Shouldn't that history inform our understanding of constitutional limitations? It was here that Crockett made the decisive move that would transform the entire argument. Rather than engaging with Thomas's historical account on his terms, she reached into her folder and withdrew a single document, a move that signaled to experienced court watchers that she was about to introduce something unexpected. Justice Thomas, you raise an important point about history informing our constitutional understanding. In that spirit, I'd like to address a specific historical document directly relevant to the original understanding of the 15th Amendment's prohibition on voting discrimination. Thomas nodded slightly, appearing interested but unaware of what was coming. Crockett held up what appeared to be an official congressional record. This is the transcript of the Senate debate on the 15th Amendment from February 26, 1869. Senator Jacob Howard, who introduced the amendment, was explicitly asked whether it would prohibit states from enacting facially neutral voting restrictions that would disproportionately burden black citizens. The courtroom grew completely still. This was not modern liberal theory, but a direct appeal to original understanding, Thomas's preferred interpretive approach. Senator Howard's response was unambiguous. Crockett continued. He stated, and I quote, "This amendment is designed to reach both open discrimination and measures that appear neutral on their face but operate to deny or abridge voting rights based on race. The Congress understands that states may seek to avoid the prohibition through ingenious devices, and we intend this amendment to prohibit all such efforts, however disguised. She looked directly at Thomas. This statement from the amendment's author directly contradicts the notion that the 15th Amendment was originally understood to prohibit only intentional discrimination. The contemporaneous evidence shows that the framers and ratifiers of this amendment understood it to prohibit both explicit racial bars and those requirements and procedures which, though neutral in appearance, would operate to disenfranchise based on race. A hush fell over the courtroom. Crockett had just presented historical evidence that potentially undermined the entire foundation of Thomas's approach to voting rights cases. Evidence drawn not from modern theories, but from the original debate on the amendment itself. The moment was made more powerful by the fact that Thomas himself was the court's most prominent originalist, someone who had built his judicial philosophy around the idea that constitutional provisions should be interpreted according to their original public meaning. Now he was confronted with original evidence that contradicted his long-held position. Thomas sat perfectly still, his expression unreadable. After several seconds of silence that felt much longer, he finally asked, "Ms. Crockett, where did you find this transcript? I don't recall seeing this statement in previous briefing on 15th Amendment jurisprudence." It was the opening Crockett had anticipated. "Justice Thomas, this statement was indeed part of the official record, but appears in a section of the Congressional Globe that has been overlooked in previous scholarship. We located it while conducting comprehensive research on original understandings of the Reconstruction Amendments. I've provided the full citation and context in our supplemental brief on page 27. She handed copies to the court clerk for distribution to the justices. The reason this evidence hasn't appeared in previous cases is revealing. Until recently, these particular volumes of the Congressional Globe hadn't been fully digitized and searchable, making this specific debate difficult to locate. Our research team discovered it while conducting a comprehensive word-by-word review rather than relying on indexed terms. As the justices received and examined the documents, the audience remained in stunned silence. Crockett had presented historical evidence that potentially undermined decades of Supreme Court precedent limiting the scope of the 15th Amendment. And she had done so using originalist methodology, Thomas's own preferred approach. Thomas studied the document intently, his usual judicial poker face slipping momentarily to reveal what observers would later describe as genuine surprise. For over 30 years, he had advanced a particular understanding of the 15th Amendment's scope. Now, in a single moment, that understanding was being challenged not by modern liberal theory, but by the amendment's framers themselves. The silence stretched for what seemed an eternity. Other justices glanced between Thomas and Crockett, recognizing the extraordinary nature of the moment. Finally, Chief Justice Roberts, perhaps sensing the unusual tension, asked, "Ms. Crockett, how would you suggest this original understanding should inform our application of the 15th Amendment to modern voting regulations?" As Crockett began responding to Roberts's question, articulating a framework that would align modern voting rights jurisprudence with the original understanding she had uncovered, Thomas remained uncharacteristically silent. For the remainder of her argument, he did not ask another question, a silence that courtroom veterans immediately recognized as highly unusual for a justice who had become increasingly vocal in recent years. The dynamic in the courtroom had completely changed. Other justices, including Barrett and Kavanaugh, engaged actively with Crockett's originalist framework, asking thoughtful questions about how it might be applied to the specific regulations before the court. Throughout, Thomas sat in silence, occasionally examining the historical document Crockett had provided. When Crockett's time expired and she returned to her seat, legal observers in the courtroom exchanged meaningful glances. They had just witnessed something extraordinary, a moment when a single historical fact, presented at the highest level of the judiciary, had visibly shaken one of the court's most firmly established judicial philosophies. Thomas's stunned silence spoke volumes about the potential impact of this revelation on the future of voting rights jurisprudence. The impact of Jasmine Crockett's confrontation with Justice Thomas spread rapidly beyond the Supreme Court chamber. As the session concluded and spectators filed out, the hushed whispers in the hallway quickly grew into animated discussions. Journalists rushed to file their stories, legal commentators scrambled to analyze the implications, and social media exploded with reactions. By the time Crockett descended the marble steps of the court, news crews were already assembled. Reporters shouted questions about the historical evidence she had presented and Thomas's reaction. Maintaining her professional demeanor, Crockett responded, "Today wasn't about any individual justice, but about ensuring the court has the full historical context for interpreting the Reconstruction Amendments. As someone who believes in the importance of original understanding, I wanted to make sure this significant historical evidence was properly before the court." Her measured response only enhanced the growing impression of her as a serious constitutional scholar, rather than a political figure seeking confrontation. Within hours, Node's original 15th and now Crockett evidence were trending nationwide. Legal blogs and news sites rushed to analyze the historical document she had presented, with many scrambling to access the original Congressional Globe records to verify her claims. "In 20 years covering the Supreme Court, I've never witnessed anything quite like today's revelation," remarked Nina Totenberg on NPR that evening. Congresswoman Crockett appears to have uncovered historical evidence that directly challenges decades of Supreme Court precedent on voting rights, and she did it using originalism, typically associated with conservative jurisprudence. Cable news networks quickly assembled panels of legal experts to discuss the confrontation. On CNN, Jeffrey Toobin called it potentially the most consequential discovery in voting rights law in a generation. On MSNBC, a panel of constitutional historians confirmed the authenticity of the congressional record Crockett had cited, with one noting that this could fundamentally alter our understanding of the 15th Amendment's original scope. Even on Fox News, legal analysts acknowledged the significance of the historical evidence. "If this congressional record is accurate," noted one conservative commentator, "it creates a genuine dilemma for originalists on the court. Do they follow the evidence of original understanding even when it leads to a result that contradicts their previous positions?" The reaction extended far beyond media commentary. Within days, voting rights organizations across the country began filing supplemental briefs in pending cases, citing the historical evidence Crockett had presented. Law professors hastily revised their constitutional law syllabi to include discussion of the newly discovered Congressional Globe passages. Most surprisingly, several prominent originalist scholars published articles acknowledging the significance of the historical record. "If we are serious about originalism as a methodology rather than a means to preferred outcomes," wrote a Federalist Society member in National Review, "we must grapple honestly with this evidence about the original understanding of the 15th Amendment." Congresswoman Crockett has performed a valuable service by bringing it to light. For Thomas himself, the fallout was clearly uncomfortable. Typically, the court's most vocal conservative voice, he was noticeably subdued during the following week's oral arguments, asking fewer questions than had become his custom in recent years. Court watchers noted that he had built his judicial legacy largely on originalist interpretations of the Constitution. Now, he faced evidence that his originalist approach to voting rights cases might have been based on an incomplete historical record, a possibility that struck at the heart of his judicial philosophy. "Justice Thomas faces a profound jurisprudential moment," observed a former Thomas clerk speaking anonymously to the Washington Post. Either he must reconsider his voting rights jurisprudence in light of this new historical evidence, or he must explain why he's setting aside originalism in this specific context. Neither option is comfortable for someone who's built his career on methodological consistency. Inside legal academic circles, the discussion went deeper than the immediate case. Constitutional scholars began re-examining other Reconstruction-era sources to see if additional evidence might have been overlooked. Several law reviews announced special issues dedicated to original understandings of voting rights protections. "What makes Crockett's approach so brilliant," wrote Yale law professor Akil Reed Amar, "is that she didn't challenge originalism itself, but instead used originalist methodology to reach a result that protects voting rights. She's demonstrated that originalism, when applied with genuine historical rigor, doesn't inevitably lead to conservative outcomes." For Crockett herself, the aftermath brought both intense scrutiny and newfound respect. Conservative media outlets initially questioned the authenticity of the historical evidence, but when multiple historians confirmed its accuracy, the conversation shifted to its implications rather than its existence. Her congressional office reported receiving thousands of messages from Americans across the political spectrum, many expressing appreciation for her substantive, evidence-based approach to constitutional interpretation. Civil rights organizations celebrated the discovery, with the NAACP Legal Defense Fund issuing a statement that Congresswoman Crockett has unearthed historical evidence that could transform voting rights jurisprudence by revealing that the original understanding of the 15th Amendment aligned with what civil rights advocates have argued for decades, that the Constitution prohibits both explicit and disguised forms of voting discrimination. The legal community's reaction was particularly notable for its cross-ideological character. A group of over 50 originalist scholars, including several Federalist Society members, signed an open letter acknowledging the significance of the historical evidence and calling for an honest re-examination of voting rights jurisprudence in light of this clearer understanding of original meaning. 2 weeks after the argument, an unexpected development occurred. During a speech at Georgetown Law School, Justice Barrett addressed the recent revelation without directly mentioning Crockett or Thomas. "As originalists, we must be willing to follow historical evidence wherever it leads, even when it challenges our prior understandings. That intellectual honesty is essential to the integrity of originalism as an interpretive methodology." The comment was widely interpreted as a signal that at least some of the court's conservatives were taking the newly discovered historical evidence seriously. The media narrative continued evolving as historians and legal scholars examined the full Congressional Globe record. Additional statements from Reconstruction-era debates emerged, further supporting the understanding that the 15th Amendment was specifically designed to prohibit disguised as well as explicit forms of voting discrimination. "What we're witnessing," wrote a Washington Post columnist, "is how a single, well-researched historical fact can potentially reshape constitutional law." Congresswoman Crockett didn't rely on emotional appeals or modern theories. She simply presented original historical evidence that couldn't be easily dismissed, even by the court's most conservative justice. The impact extended to state legislatures as well. Several states considering voting regulations similar to those challenged in the Texas case announced they would reconsider certain provisions in light of potential constitutional vulnerabilities. Legislative counsel in these states specifically cited the historical evidence about the original understanding of the 15th Amendment. 6 weeks after the oral argument, the Supreme Court announced it would issue its ruling in Harris County Voters vs. Texas Election Board the following Monday. Legal experts remained divided on the likely outcome, but many noted that Crockett's historical evidence had created a path for the court's originalist justices to invalidate the most restrictive provisions while remaining consistent with their interpretive principles. Regardless of this specific ruling, noted Harvard law professor Lawrence Tribe, Crockett's unearthing of this historical evidence will influence voting rights jurisprudence for decades to come. Some discoveries fundamentally change the constitutional conversation, even when they don't immediately change results. For Crockett, who had begun her career as a public defender representing clients who often felt powerless against the system, the opportunity to reshape constitutional understanding at the highest level represented a profound fulfillment of her commitment to equal justice. As she told a group of law students at Howard University the week before the ruling, the Constitution's promises of equality and participation belong to all Americans. By recovering the original understanding of those promises, particularly the Reconstruction Amendment's protections for formerly enslaved people and their descendants, we strengthen the case for fulfilling them today. When the court's opinion was finally released, legal scholars immediately noted something remarkable. The majority opinion, written by Chief Justice Roberts, directly acknowledged the historical evidence Crockett had presented, stating that it provides important context for understanding the original public meaning of the 15th Amendment's prohibition on denial or abridgment of voting rights on account of race. While the court didn't adopt Crockett's full interpretive framework, it invalidated several key provisions of the Texas law, finding that the combination of restrictions created a system of disguised discrimination of precisely the kind the framers of the 15th Amendment sought to prohibit. Most surprisingly to court watchers, Justice Thomas did not write a dissent as many had expected. Instead, he concurred in part and dissented in part, acknowledging that the historical evidence regarding the original public meaning of the 15th Amendment deserves serious consideration, while reserving judgment on broader implications for voting rights jurisprudence. The decision was hailed as a significant victory for voting rights advocates, but the longer-term impact may prove even more consequential. By introducing historical evidence that aligned originalist methodology with voting rights protections, Crockett had potentially bridged a gap that had long divided the court along ideological lines. What Congresswoman Crockett accomplished goes beyond this single case, observed a constitutional scholar in The Atlantic. She demonstrated that robust protection for voting rights isn't a modern liberal invention, but is rooted in the original understanding of the Reconstruction Amendments. That insight could reshape constitutional law for a generation. As for Justice Thomas's stunned silence during oral argument, that moment when a single historical fact left him visibly reconsidering decades of jurisprudence, it had already become legendary in legal circles, a reminder that even the most firmly held constitutional theories must ultimately answer to historical evidence. For millions of voters whose access to the ballot was at stake, the case represented something more immediate and concrete, a recognition that the Constitution, properly understood, protects not just against explicitly racist voting restrictions, but also against the disguised forms of discrimination that have persistently emerged throughout American history. As Crockett observed in a post-decision interview, the 15th Amendment's framers understood that those seeking to suppress votes would rarely announce their discriminatory purpose openly. They drafted the amendment precisely to reach the kind of neutral restrictions that operate with discriminatory effect. By recovering that original understanding, we honor both the letter and spirit of the Constitution. The confrontation between Congresswoman Crockett and Justice Thomas had become more than a dramatic moment in Supreme Court history. It had evolved into a case study of how meticulous historical research and constitutional fidelity could transcend political divisions and potentially reshape the law for decades to come, all from a single fact that left one of the nation's most powerful jurists in stunned silence. Thanks for watching our coverage of this historic Supreme Court confrontation between Congresswoman Jasmine Crockett and Justice Clarence Thomas. If you found this analysis eye-opening, Please hit that like button and subscribe to our channel for more in-depth coverage of the crucial legal and political debates shaping our democracy. Comment below with your thoughts on how original historical evidence can transform our understanding of constitutional rights.